3, 2, 1, we are live.
Good morning and welcome to one and all. Symbiosis Law School Pune, under the aegis of Symbiosis International Deemed University, in collaboration with OakBridge Publishing Private Limited, is delighted to host the virtual book release and discussion on Decoding Child Sexual Abuse, a socio-legal analysis of protection of children from Sexual Offences Act 2012, authored by Justice Dr. Shalini Phansalkar-Joshi. It is my honor to welcome esteemed guests and dignitaries who have graced us with their presence at this event today. On our virtual dais, we have the chief guest of the event, Honorable Justice Abhay Srinivas Oak, Judge of Supreme Court of India, our visionary founder and Honorable Chancellor, Symbiosis International Deemed University, Dr. S.B. Majumdar, sir. We also have Director, Symbiosis Law School Pune, and Dean Faculty of Law, Symbiosis International Deemed University, Dr. Shashikala Gurpurma. A special note of welcome to the author and former Judge, High Court of Bombay, and distinguished visiting judge scholar in residence of the Faculty of Law, Symbiosis International University, Justice Dr. Shalini Phansalkar-Joshi. It is indeed an honor to welcome you all to this event. I also extend a warm welcome to the members of bar and bench, scholars, faculty members, and students who are joining us as attendees at this event today. We will now commence the program with the virtual lighting of the lamp.
Ya kundendu tusharahara dhavala, ya shubhravasravruta, ya veena varadanda vanditakara, ya shveta padmasana, ya brahmachyuta shankara prabhutibhihi देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा शुक्लां ब्रह्मविचारसारपरमा आद्यां जगद्व्यापिनीम् वीणा पुस्तकधारिणीम् अभयदाम् जाड्यान्धकारापहाम् हस्ते स्फाटिकमालिकां विदधतीम् पद्मासने संस्थिताम् वन्दे तां परमेश्वरीं भगवतीम् प्रदां शारदाम्.
Thank you. It is now my privilege to introduce Dr. Shashikala Gurpur, Fulbright Scholar and Jean Monnet Chair Professor, Director, Symbiosis Law School Pune, and Dean Faculty of Law, Symbiosis International University. With more than 27 years of teaching experience, including tenures from NLSIU Bangalore to University College Cork, Ireland, Dr. Gurpur is listed as one of the 100 legal luminaries of India by LexisNexis. She has more than 72 scholarly articles and research papers, 2 co-authored books, and 12 book chapters to her credit. She has acted as an advisor to research projects and publication for Asian Network of Women in Communication sponsorship by WACC UK. She has been conferred with the prestigious annual Kittur Rani Chennamma Award for the years 2018 to 19 by the Government of Karnataka for her excellent achievement in the field of education and contribution towards women empowerment. She is nominated as the member of the MCCIA Corporate Legislation Committee for 2020 to 22, and she is a distinguished member of the editorial boards of LexisNexis Butterworth, Journal of IPR by CSIR, Law and Policy Journal Dublin, Ireland, and Polish Law Review. She's a project manager for 4 EU projects undertaken at SLS Pune, and now the chair professor for the prestigious Jean Monnet Chair on Climate Justice and Law. I invite you, ma'am, to kindly deliver the welcome address.
Good morning, respected Chief Guest, Justice Abhay Oak, Sir of Supreme Court, the Presidential Chair, Dr. S.B. Muzumdar Sir, our Honorable Chancellor and founder of Symbiosis, Dr. Rajni Gupte, our esteemed Vice Chancellor, and Dr. Shalini Phansalkar, Madam, who is the Utsav Murthy or the chief personality today, whose lifetime work we are going to unveil and discuss around the theme, which is of major concern to our country. Welcome to each and every one of you on the dais. I would like to humbly submit before you. I welcome you from a forum which is Symbiosis Law School, Pune, which is home to wonderful students and which has year on year repeated its excellence, being ranked among the top 10 law schools in the country. We are also situated in a home, namely Symbiosis, which in itself stands for diversity, excellence, and justice and voice to the voiceless, which is international students way back in the 1970s landscape of Pune, which inspired the founder to develop this greatest educational experiment in the private sector. Dear all stakeholders in the rule of law, in the form of judges, lawyers, retired and working, in the form of law students, non-governmental organizations, friends of Justice Shalini Phansalkar, friends of Symbiosis Law School, friends who believe in the cause of rendering voice to the voiceless. I'm very happy to share with you that today's function is a gift of time, a reward which was forwarded by three factors. One of the public intellectuals who was a great friend of our founder Chancellor, Dr. Muzumdar Sir, late Advocate Ranade, who brought Justice Shalini Phansalkar's name to our attention way back when I started my career here in 2007. We were waiting for ma'am to come, but she was very, very busy with her innovative experiments in the family court and family justice in Pune. So we got a wonderful opportunity. The second coincidence brought by time was the Symbiosis family's close relationship with the Justice Chandrachud sir, who was on our board of studies, who did the real formal introduction to Justice Shalini. So he not only wrote the foreword to this great book, but also foreword to Symbiosis's relationship with Dr. Shalini. So I must say that when Madam was the director of Maharashtra Judicial Academy, our synergy started in imparting a joint course to our students in judicial skills. It is for the first time that any law school was formally collaborating with the Judicial Academy. Madam, being a person standing for innovation, also shows it as part of our family in a very open arrangement where she's the visiting judge scholar in residence. This experiment was initiated and visualized by our Pro-Chancellor, Dr. Vidya Eravdekar, and our Chancellor, Dr. S.B. Muzumdar Sir, in order to render students the latest ideas in judicial training and also to bring the rich experience of judges. We have many judges, many ambassadors and others who are enriching our landscape of such experiential learning for our students. I am happy here to share with you that our own experience through our community legal service was the third gift, which was bringing this function into a kind of synergy of values, ideas, and mission. Now, what is that? In the initial years of moving to this beautiful campus in Viman Nagar in 2014, we took so much of cognizance of a case of a girl child who was refused admission in schools because she was a complainant in a sexual abuse case by the conductor of the former school in which she was a student, where the conductor was booked after the huge protest by the citizens and women of Pune. So here, the law school intervened in terms of getting her admission, in providing her support, in getting her post-traumatic stress relief, special counseling with the collaboration of Pune's Armed Forces Medical College. Now, it was 2014. 2016, when I engaged in Karnataka's sex workers' rights report with the then legislator, Ms. Jayamala, I came to know that sexual abuse of a child, the post-trauma experience, is much more intensive than a Vietnam War victim. I mean, this is cited in the medical literature. So it made us quiver with the kind of compassion never heard before, where our students engaged, our teachers engaged, our visiting faculty, Ms. Chaitrali, took the lead in seeing that this girl was rehabilitated beyond the legal provisions in the social reality. If there is any expression to such hidden reality in the society and the concerns that law needs to again and again reiterate and renew itself in its personnel, in its vocabulary, in its reform, is giving voice to such voiceless, which again is revealed in the foreword by Justice Chandrachud sir. Now, today's function in a way symbolizes all these engagements in law reform by the school, by our stakeholders, and invitations that we received from the Ministry of Law and Justice, National Judicial Academy, National Judicial Grade, National Women's Commission, among many others. We have been given the sanction to the Pro Bono Club by the Ministry of Law and Justice, Government of India, just 3 days ago. So this shows that, as I welcome you all, we once again reiterate as a law school, as one of the facets of rule of law, namely legal education, our commitment to the cause, which forms the core theme of this book, the plight of children who are sexually abused. Beyond that, we also reiterate our commitment to the cause of justice, to the vulnerable, and to the livelihoods and lives, which I will further highlight as I unveil the highlight of the book later on in the opportunity given to me in this function. I would like to say here that today we have weaved a beautiful story in the form of this event in coming together with the publisher, namely OakBridge, who have taken the initiative to unveil these realities to the humanity. We are also weaving the voices which are hidden in this book, in the cases, in the plights of judges also, police also, in dealing with such cases, with the kind of social ignorance and apathy in looking at how a child's suffering is, in what Sheila Barse said, their innocence as a burden. We are also bringing here some of our own sad experiences, where I was reading about how when the most abusive parent meets a child in the court, first thing the child does is hugging that parent. So this is the kind of burden that a child unburdens itself in the form of unconditional love, which every child deserves. And therefore, the focus of the book in terms of both protection through the law and prevention by law and other agencies is very, very timely. I'm very happy to welcome each and every one of you to this great, delightful occasion, which also has a pensive note and undertone to it, while at the same time unveiling the marvelous scholarship, mission, and dedication, and the hard work of Dr. Justice Shalini Phansalkar Joshi in terms of this book, which will no doubt become a ready reckoner for every law school to develop a new course or to enrich the existing course, which will become a researcher's delight in putting together the latest case laws and approaches, which will become a handbook and a checklist for every judge and police officer in this country, beyond which it could be a good, admirable resource for future judges and future activists who involve in this cause. As I welcome all of you, I'm very happy to state here that all law schools are very much engaged in this social agenda of working towards the vulnerable through the community legal service arm, which is running under university's extension and outreach wing. So I welcome each and every one of you to Symbiosis Law School Pune virtually. And I also wish and pray that the days won't be too far that we would be welcoming you in reality in a live session where we will further expand this team, probably in a sequel to this great research. Welcome, one and all.
Thank you, ma'am. Thank you for that warm welcome and apt introductory note to the scholarly work that we are celebrating today. We are also pleased to note the presence, as mentioned by Dr. Gurpur, of our Honorable Vice Chancellor, Dr. Rajni Gupte ma'am, as well as the Director of OakBridge Publishing, Mr. Shrish Chandra, as well as many of the members of Bar and Bench and directors and deans and leadership of our esteemed institutions. Now, to deliver the presidential address, I have the honor of introducing Professor Dr. S.B. Majumdar Sir, founder and chancellor of Symbiosis International University. Dr. Majumdar is a recipient of the Padma Shri in 2005 and the Padma Bhushan in 2012. In 2016, Dr. S.B. Majumdar Sir was conferred the D.Lit by Tilak Maharashtra Vidyapeeth. He is also the recipient of the first Dr. APJ Abdul Kalam Memorial Award in 2016. He received the Punya Bhushan Award in 2009, the FIE Foundation Puraskar in 2006, the Maharashtra Gaurav Puraskar in 2003, the Top Management Club Pune's Excellence in Education Award, the Rotary Club of Pune's Service Excellence Recognition Award, to name a few. He has published over 50 original research articles in several national and international scientific journals. He has authored several books on life sciences and has contributed over 200 articles on science, education, and youth development. He has also been the chairman of the educational wing of FICCI in 2005 and 6. We are very honored to have you join us, sir. Very warm welcome to you. I would now like to invite you to deliver the presidential address.
Firstly, to all of you, today's chief guest, Justice Oak of Supreme Court, Justice Shalini Pansarkar Doshi, our Vice Chancellor, Dr. Gupte, Dr. Justice Mohit Shah, staff members, friends, and all students who are listening to all of us. I congratulate Justice Shalini Pansarkar Doshi on writing a book on decoding sexual abuse. Shalintai, you are very lucky because it is being launched at the hands of Justice Oak of Supreme Court, and the foreword has been written by Justice Dhananjay Chandrachud. I am really happy that you are associated with Symbiosis Law College. Justice Oak Sahib, we started Symbiosis Law College way back in 1977 because there was only one law college in Pune, established in 1924. And that law college was imparting law courses only in the morning. But that was the time when there were many industries which were established in and around Pune, and they wanted, officers in this industry wanted evening law college. And therefore we started law college in 1977, both for morning and evening sessions. That is how our law college was established. It was the second law college in Pune, way back in 1977. I am glad that this law college is now recognized all over the country as among top 10 law colleges. Well, I am not competent to speak on the book because I happen to be a professor of botany at Ferguson College. But let me tell you one thing. that universities have professors, associate professors, and assistant professors. And according to University Grant Commission, they require certain qualifications. Teaching experience at degree level, and above all, everyone should be PhD. Whether he is professor, whether he is associate professor, whether he is assistant professor. And these professors, they teach students in the classroom and they cover the syllabus which is prescribed by the university. In other words, professors prepare students for examinations so that students get degrees. But there are many other areas outside the syllabus, outside the curriculum, which require experts in different fields. And therefore, we created a category of distinguished professor. For example, we have an institution called Symbiosis Institute of International Studies. And we have appointed visiting professors who are former ambassadors. For example, Gautam Bambawale, former Foreign Secretary Vijay Gokhale, are the visiting professors there. They bring practical experience in the classroom so that the vision and the knowledge of students is considerably wide. Similarly, I am glad that Shashikala has succeeded in associating many retired High Court judges and even Supreme Court judges in order to give a wider vision of the knowledge in law to our students. I still remember our Jethalani, who used to teach regularly to the students, at least once or twice in a month. He used to specially fly from Delhi to Pune only to teach our law students. And I'm very happy that Shalini Doshi, Professor Doshi, is also associated as visiting professor, and she is distinguished visiting judge of this college. Now, the only I personally feel, being a teacher myself for many years, I still feel that their very presence on the campus is an inspiration to our students. And although they are retired, they have enthusiasm, they have energy, they have many ideas, and I'm sure Justice Professor Doshi must have crystallized those ideas in this present book. And I'm read casually that it is based on your thesis which you submitted for PhD. So, association of distinguished professors goes a long way in enriching the students' knowledge in different fields other than those topics which are prescribed in syllabus. I am really happy that Justice Oak, you have found time to address our students, and I hope you will visit our college and address our students physically in the future. With these few words, I once again congratulate Professor Doshi, Shalini, and I hope you will continue to associate yourself with this college and inspire our students, and not only students, but even our professors. Thank you.
Thank you, sir. Thank you for your inspiring and encouraging words, your support and the commitment to justice and education. It's always encouraging. Thank you very much. It is now my privilege, without any further ado, to introduce the author of the book, Decoding Child Sexual Abuse. Justice Dr. Shalini Phansalkar Joshi is the former judge of Bombay High Court, having just retired with experience of more than 3 decades of working as a judicial officer in various capacities as principal judge of City Civil and Sessions Court, Mumbai, District and Session Courts at Pune, Special Court for Trial of Cases of Atrocities Against Women, Principal Magistrate of Juvenile Justice Court. She has also worked as Judge of Family Court at Pune and then as the Registrar General of Bombay High Court. She has done her master's and doctorate in law from Pune universities in the subject of child sexual abuse from socio-legal perspectives. She is presently on the panel of examiners for PhD candidates in Mumbai University. Presently, she is a distinguished scholar judge in residence at Symbiosis Law School, Symbiosis International University. She was the joint director and thereafter the officiating director of Maharashtra Judicial Academy in its nascent stage and has trained, nurtured, and mentored entire district and trial court judiciary in Maharashtra. She has conducted training programs for judicial officers, police persons, public prosecutors, members of the bar, probation officers, and other stakeholders in national and state judicial academies and law colleges. She has acted as a resource person in national and international conferences. Her areas of special interest are juvenile justice, gender justice, human rights, and constitutional law. She is the First Lady Advocate from Karad and First Lady Judge from Satara. She is the recipient of many awards like Spurti Puraskar and Karad Bhushan. She has the distinction of being the British scholar in the subject of gender and law and having fellowship of Commonwealth Judicial Education Institute in Canada in judicial education. She has authored training modules on the subject of sex selection and PCPNDT Act and human trafficking, which are used widely by all state judicial academies. She has authored the book on compilation and analysis of case law on the subject of PCPNDT Act. Her contribution of articles on subjects relating to law in criminal law journals, All India Reporter, and other journals is numerous. We are very honored to welcome you today, ma'am, in the honor of your book release, and I would like to invite you to deliver your address.
Thank you so much, Lasya. Honorable Justice A.S. Oak, Judge, Supreme Court of India, Dr. S.B. Muzumdar, Honorable Chancellor, Symbiosis International University and founder and president of Symbiosis, Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, and Dean Faculty of Law, Symbiosis University, Mr. Shrish Chandra, Director, OakBridge Publication Private Limited, Assistant Professor Lasya and other directors and faculty members of Symbiosis Law School, Pune, Justice Mohit Shah and all the esteemed judges, judicial officers, legal luminaries, and distinguished members of the bench and bar, the principals and faculty members of the law colleges, my colleagues from different fields, my loving family members, dear friends, and equally dear students, and of course, all the participants who have joined from various corners of the country and the globe. It is simply a great occasion for me, a moment of satisfaction and celebration, to be blessed with presence and well wishes of all my dear and near ones. It is my maiden attempt of writing the book, and I am overwhelmed with the warm response which I am receiving. This book, which was initially prepared as a dissertation for the award of PhD degree in law, deals with the most agonizing and serious issue of child sexual abuse, a malady which is affecting all strata of society across the world, irrespective of caste, creed, sex, or religion, and is spreading widely. It is the most closely guarded secret of the family and the society. This malady is in the nature of a scar on humanity and civilization, as it is a crime against the most vulnerable, helpless, and voiceless class of society, the children who are insignia of the innocence, and it is their innocence which becomes their burden. There are no words to condemn it and no laws are adequate to deal with it. In these crimes, the child, the very delicate, innocent, and loving being on this earth, the most precious creation of Almighty and personification of God, is at the receiving end of their beings. That too at the hands of those persons who are entrusted with the duty of looking after and protecting it. No other crime or abuse can be greater than the betrayal of faith by your own blood relative or close confidant, and that too in such a heinous and barbaric way of sexual abuse. Nothing is more heartbreaking than to know that child victim is further victimized by the very system to which it approaches for the redress of the grievances. It is the failure of the justice delivery system at times that it finds itself unable and unequipped to cope with the trauma faced by such child and to effectively deal with the offender. It is also at times the failure of the society that it cannot prevent such abuse taking place. Of course, no society wants its future to be damaged. No system of justice delivery will tolerate the victim to be left without justice and further victimized. Some ways, some means have to be found out to arrest the process of dehumanization and degradation of civilization. My thesis, written in the year 2000, was to address this very malady and to suggest the means to stop the secondary victimization faced by the child victims in the investigation and the trial process for want of adequate laws and procedure. The model code of legislation suggested by me in the thesis is now found reflected in the recently enacted legislation of the Protection of Children from Sexual Offences Act 2012 and amended in 2019. This book is an attempt, therefore, to demystify the phenomena of child sexual abuse as to what constitutes child sexual abuse, how widespread it is, and its damaging impact on children, with a view to create awareness about the problem which has remained so far hidden, and to suggest remedies to deal with it and to prevent it. In this book, an attempt is also made to analyze the various novel provisions made in the Act, like mandatory reporting, the reverse burden of proof, the enhancement of age for consensual sex, etc., and to clear these gray areas surrounding them. This book is an effort to make the law not only effective and judicious, but to make it more equal, human, and sensitive to the child, to advance its operation for the benefit of whom the law was made, that is the children. For writing this book, all the available material in the form of the book, very few books available, the findings of surveys conducted by various NGOs, more than 200 reported decisions of various high courts and Supreme Court of the last about 3 decades are critically studied and analyzed. A comparative study of parallel developments under the English, American, and other laws has also been attempted. It is earnestly hoped that this book would be useful to law students, judicial officers, academicians, parents, school teachers, and laypersons also, in spreading awareness about this worldwide phenomenon of child sexual abuse, its seriousness, its long-standing effects and implications, in highlighting the trauma and secondary victimization faced by the child in the justice delivery system, The corresponding difficulties faced by the police and the court in investigation and trial court process, in understanding the POSCO Act and in inculcating the need for sensitization for prevention and detection of such abuse. It is sincerely hope that this book will serve this purpose to some extent at least. To quote the words of 84th Law Commission report published in 1980, and here I quote, I do not delude myself into thinking that my proposals or recommendations will bring into the investigation and trial of cases of child sexual abuse a state of perfection. Sometimes one's best endeavors go awry. What I attempted to do is to strike a balance between the interest of the accused and those of the victims, and thus to protect the interest of the society. I expect no greater victories from researchers. It may be treated as just a beginning. The success of the book will be achieved if it wipes the tears of those who are victims of sexual abuse and gives solace to them. At the same time, prevent other children from falling prey to the menace. No words can fully express my gratitude to persons and institutions that helped me in writing this book. First and foremost, I would like to express my heartfelt thanks to my husband, Shashankan Joshi, my two children, Ranmani and Ame, and my both the families without whose active help, encouragement, and understanding, it would not have been possible to complete this work. I am most grateful to Professor Durgambini Patel, my teacher and guide, for her constant guidance and encouragement in preparation of my thesis. I owe my deep gratitude to the tacit support, encouragement, and inspiration extended to me throughout my judicial career and thereafter also, from various Chief Justices, from my colleagues on the bench and bar, then my colleagues in the academies, law schools, and other fields, judicial officers and trainee judges, who my interactions with them always supplied me with new insights on this subject. I am extremely grateful to Honorable Justice D.Y. Chandrachud, the Judge Supreme Court of India, for readily agreeing, despite his hectic schedule, to pen the foreword for this book in his inimitable style, which is a value addition for this book. I am equally grateful to our today's Chief Guest, Honorable Justice A.S. Oak, the Judge Supreme Court of India, and who has always remained my ideal on judicial side and also on academic side, and who has on the very first call from me willingly accepted my invitation to release the book, that too despite heavy demands on each time and despite this pandemic situation which has affected greatly. I owe a deep sense of gratitude to today's guest of honor, the Chancellor of Symbiosis, Dr. S.B. Muzumdar, for being with us to bless this occasion. I happily remember, sir, that long back in the year 2002, I had received Spurti Puraskar at Kanya Shala at his auspicious hands. His presence today for this event is a blessing for me. No words can express my feelings of gratitude for Symbiosis Law School, especially its Chancellor, Dr. S.B. Muzumdar, Vice Chancellor, Dr. Rajni Gupte, my beloved colleague, Director, Dr. Shashikala Gurku, who have most willingly offered to host this event. I am also greatly indebted to entire faculty and staff members of the Symbiosis Law School, who have taken great efforts in making this event possible despite the current pandemic situation. I am equally grateful to the OakBridge Publishing House, especially to its director, Mr. Sharish Chandra, for putting their faith in a new author, their editing team led by Priyanka Srivastav and marketing team led by Sachin Tripathi. Last but not the least, I am most grateful and indebted to those child victims who have appeared before me, physically in person in the trial courts or through their cases in reported decisions, whose agony and trauma has compelled me to undertake this project. Like my thesis, this book is also dedicated to them. Thanking you. Thank you.
Thank you, ma'am. Thank you for those eloquent words, sharing with us the motivation and the purpose for writing and publishing this book. We will hear once again from ma'am during an upcoming conversation and the question answer session. But for now, we will go ahead with the book release. So in the august presence of the chief guest and the dignitaries on the dais, I would now like to invite Honorable Justice Abhay Srinivas Oak sir, Dr. S.B. Majumdar sir, Dr. Rajni Gupte ma'am, Dr. Shashikala Gurpur ma'am, to join Dr. Justice Shalini Phansalkar Joshi ma'am in unveiling and releasing the book, Decoding Child Sexual Abuse, a Socio-Legal Analysis of Protection of Children from Sexual Offences Act 2012. Thank you. Thank you to all the dignitaries. Thank you to the chief guest and all the dignitaries for the release of the book. For those who would like to purchase the book, it is available for online purchase by following the link that has been inserted in the slide. The link will also be provided in the chat toward the end of the program. So please do wait for that. It is now my privilege to introduce the chief guest of the event, Honorable Justice Abhay Srinivas Oak, a graduate of BSc LLM from the University of Bombay. Honorable Justice Abhay Oak started practicing in Thane District Court in the chamber of his father, Srinivas W. Oak. In 1985 and 86, he joined the chamber of a former judge of the Bombay High Court and former Lokayukt, Sri V.P. Tipnis. He appeared in several important matters in public interest litigations. He was elevated as the additional judge of the Bombay High Court in 2003 and was appointed as a permanent judge in 2005. His lordship took oath as the Chief Justice of High Court of Karnataka in 2019. After an eventful tenure as the Chief Justice, Justice Abhay Srinivas Oak had been elevated as a judge of the Supreme Court of India on 31st August 2021. During his tenure, which lasted for more than 2 years, Justice Oak pronounced several notable verdicts in matters pertaining to the environment, human rights, and criminal justice system. These verdicts reflect a strong commitment to uphold and nourish the rule of law. Apart from a series of judgments on important public issues like coastal zone regulations, wetland dumping grounds, noise pollution, political holdings, regulation of illegal structures, etc., Justice Oak played a significant role as an administrative judge as well. In his judicial career, Justice Oak firmly battled for clean environment and better living conditions. Even during the pandemic, Justice Oak's bench was vigilant and proactive in upholding rights. It is a high honor, sir, to welcome you in this program today, and I would like to invite you to now deliver the chief guest address.
Before Justice Oak starts his address,
Yes, sir.
Shashikala, may I request you to have a group photograph?
Yes, sir. Yes, it will come.
Let's have a group photograph.
Yeah, there was some kind of a.
So that all of us have a group photograph.
Yes, it was disappearing. So, Amit, could you all, technicians, could you all?
Yes, ma'am. Yes, yes.
Because when Chief Guest Sir was holding it, it was disappearing. Yeah. So, can you see your proper photos?
Good. Thank you.
Thank you, sir, for that thoughtfulness. Yeah.
Thank you very much, sir. I invite Justice Oak, sir, to deliver his address. Sir, could I request you to please unmute yourself? Sorry.
Dr. S.B. Majumdar, Honorable Chancellor, Symbiosis International University, Vice Chancellor, Dr. Rajni Gupte, my esteemed sister colleague, Justice Dr. Shalini Joshi Phansalkar, my own Chief Justice in Bombay High Court, Justice Mohit Shah. I see names of many sitting judges of the Bombay High Court who have been my brother and sister colleagues. I take names of few, but it is impossible to read list of more than 500 participants. I see Justice K.R. Shriram, Justice Kotwal, Justice Vibha Kankanwadi. Many of my former esteemed colleagues in Bombay High Court have also joined. I see the names of Justice Rohi, Justice Mudula Bhatkar, Justice Pratibha Upasni, Justice Sathe, and many others. Dr. Shashikala Gurupur, Director of Symbiosis Law School. Shrish Chandra, Director, OakBridge Publications. Professor Lasya, judicial officers, distinguished members of the bar, faculty members of Symbiosis Law School, faculty members of various law colleges in the state, and dear students. It is indeed a great privilege for me to be part of this function to release book by my esteemed sister colleague, Decoding Sexual Abuse. It is also a great privilege for me to get associated with Symbiosis Law School, which is one of the most leading and well-known law schools in the entire country. I must respond to Dr. Muzumdar by telling that as judges of the Constitutional Court, it is our obligation and duty to support the cause of legal education. So whenever my presence is required in Symbiosis Law School, I'll be too willing to come. It always gives me a great pleasure to interact with young law students. We get so many new ideas after interacting with the law students. Firstly, I must say a few things about my esteemed sister colleague, Dr. Justice Shalini Joshi Phansalkar. For years, I know her in different capacities. I had privilege of appearing before her when she was a civil judge at Thane in one of the cases. I worked with her as guardian judge of the Pune Family Court, as guardian judge of the City Civil Court, Mumbai, when she was the principal judge. I was associated with the Maharashtra Judicial Academy when she was the joint director. And I must say, as a joint director, she made several innovations. She brought about several interesting changes in the curriculum for the judicial officers. She was Registrar General in Bombay High Court. Thereafter, she was a judge of Bombay High Court, my esteemed colleague. Thereafter, my association with her continued. As Patron-in-Chief of Karnataka Judicial Academy, I was privileged to have our sister as one of the visiting faculty members, and I am happy to note that her association with Karnataka Judicial Academy still continues. I must say that I am not an academician, so it is not my province to decode the book written by my esteemed colleague. It is actually a very phenomenal work done by Sister Shalini. We must appreciate one thing, that most of the parts of the book are written when Protection of Children from Sexual Abuse Act 2012 was not even enacted. It was brought into force on 14th of November 2012. Though I'm not going to deal in great detail about the book, what is most interesting is chapter 2, where Justice Shalini analyzes what constitutes child sexual abuse. it's a very, very elaborate discussion by her on what constitutes child sexual abuse. She has referred to brutal assault and subtle assault. I will sum up this chapter by saying only one thing. Whenever our legislators choose to again amend this 2012 Act, they should apply their mind to what the author has said in chapter 2. I personally believe that there is a need to expand the definition of sexual abuse. And this chapter 2 will be an ideal tool to decide in what manner we can expand. There is one chapter which will shock conscience of any citizen. That is a chapter under the heading, How Widespread the Child Sexual Abuse is. After I went through this chapter, though I have worked as a judge for more than 18 years, I was really in a state of shock. It is really an eye-opener. Justice Shalini has not stopped at that. She has dealt with the impact of this widespread sexual abuse on our society. She has discussed solutions. She has given her own suggestions. And she has rightly described that enactment of this 2012 Act is only a beginning. We have much to achieve. We are going to have elaborate discussion on this book, and therefore I'll not spend much time on this. But I must take this opportunity to deal with few issues concerning POCSO. As I said, in November 2022, this legislation will complete 10 years of its existence. I always believe that when such a progressive legislation is brought into force, after periodical intervals, it is necessary to have a very scientific audit of implementation of the provisions of such enactment. I am talking about scientific audit. It's not about the figures of conviction, the figures of acquittal, the number of special courts which we have, the infrastructure we have for these courts. Of course, these are not insignificant factors. But when I am suggesting audit of implementation, I mean something else. We, the members of the legal fraternity, we always talk about docket exclusion. Docket explosion, not exclusion. But according to me, the real issue is docket exclusion. Audit is required to ascertain how many cases of gross child sexual abuse have not been reported or recorded. How many cases have not come to the court? How many cases have not been noticed by the law enforcing agencies? The chapter written by the author also indicates that there are several cases in our country where children silently suffer sexual abuse. The reasons are multiple. Unfortunately, these helpless children do not know what is sexual abuse. There is lack of awareness on the part of their parents. There is lack of support from the family. There are other social conditions which prevent the children, the affected children or their families from approaching law enforcing agencies. As the author has rightly said a few minutes back, the trauma of the victim child does not end by suffering the assault. The trauma continues when our law enforcing agencies, the police, deal with the issue. The agony continues the way sometimes the court proceedings are conducted. The reason is lack of sensitivity on the part of all those who are part of law enforcing machinery. There is a lack of knowledge. In fact, one section of this 2012 Act, which is hardly implemented, is Section 43, which is the requirement or obligation of the state of ensuring public awareness about the provisions of law. Rule 3 of 2020 rules also deals in detail with this aspect. Unfortunately, the parents do not know what is sexual abuse of children. There is no systematic effort on the part of the state to spread awareness. That work is being done by law schools, many NGOs, and many individuals at individual levels. There are government organizations like NIMANS, which are doing good job in the field. There is one more provision which requires the boards at national level and state level to monitor the functioning or implementation of the Act. It's a matter of debate what contribution these authorities at national and state level are making. The efforts which are there to bring about awareness about this legislation are at level of NGOs, at individual levels. But at the state level, we don't find any concentrated effort. This is the most neglected area of developing awareness about the provisions of the law. Then comes the sensitization of police. Those who are associated with judiciary or those who are lawyers, they know how insensitive are our special juvenile police units. Firstly, they are hardly functional. And I must candidly say that the lack of awareness, lack of sensitization is not confined to police. To some extent, we who are members of the judiciary, we also display lack of sensitiveness. There are aberrations, I can't deny that. The lack of sensitivity on the part of the public, special public prosecutors, perhaps they are not given proper training. There is a provision under the Act that when a child is in the witness box, the child should not be intimidated. The child should not be questioned in aggressive manner. But during last few years, I have seen as a judge, when we deal with appeals or other proceedings arising out of proceedings before the special court, the manner in which lawyers aggressively cross-examine the child. There is a mandate of the law that you should not be aggressive, but that is not happening. Here comes the role of Bar Council. Fortunately, in Maharashtra, Bar Council of Maharashtra and Goa is conducting several programs for the lawyers, continuous legal education program. And some of the programs do have this subject, but the Bar Council need to concentrate on that and educate the young lawyers. More than in any other category of matters, in this category of matters, the members of the bar must remember that they are first the officers of the court and thereafter the mouthpieces of their respective clients. Section 33 contemplates child-friendly atmosphere in the court. Are we really creating child-friendly atmosphere? Of course, I must say that not as a general rule, but I can say that there are many child-friendly courts created in our country. There are many in Delhi, for example, Saket. One or two good courts are created in Maharashtra. Some of them are there in state of Karnataka. The setup of the court should not look like a normal court of law. Even if you have that good setup, that is not sufficient. the responsibility of maintaining child-friendly atmosphere is on the investigating officers, is on the special public prosecutors, the lawyers who appear for the accused, the lawyers who appear for the victim, and most importantly, the judge of the special court. Today, unfortunately, in our state, we lack adequate judicial infrastructure. Therefore, most of the special courts, though in the interior part they are modified, they form part of the larger court complex. And when the child, along with the parents, enters the court complex, the child is exposed to that typical atmosphere in our court complexes. There are too many litigants around, there are criminals around, there are police officers. Therefore, what we are endeavoring to do is to ensure that the child-friendly court should have separate access so that the child, along with her relatives, need not enter the court from the same access which is used by litigants and lawyers and accused. Ideally, there should be a separate child complex, which is far away from the traditional courts. But of course, when it comes to judicial infrastructure, we don't live in an ideal world, and our infrastructure is lagging far behind. Therefore, we must remember that the physical infrastructure of a child-friendly court is something which is minimum. But more than that, what is required is the approach, which will really ensure, approach of the stakeholders, which will really ensure that there is child-friendly atmosphere in true sense in our special courts. There are many innovative provisions in the Act. One such provision is Section 21, which provides that even failure to report and record an offense under the Act is itself an offense. I have rarely seen this section being invoked. There are cases and cases where even the parents hesitate to report such incidents. There are cases and cases where the complainants are turned back by the police because they lack sensitivity. But hardly this Section 21 has been invoked. Rule 4 of Rule 220 rules, 2020 rules contemplates care and protection of the child who is victim of the offense. This is one area where again we are lacking. In fact, under Section 33, subject to correction, it is subsection 8, there is a very innovative provision, a salutary provision for rehabilitation of the victims. There are convictions under the provisions, but in true sense, are we rehabilitating the victims? We may be paying them compensation in terms of the scheme which is available, which is being implemented by the state and district legal service authority. But that is only a small and fractional component of true rehabilitation. The rehabilitation contemplated by Section 33 has a different connotation. But somehow we are not able to rehabilitate the victim of offense. Today, the entire face of the society is undergoing change. We see several peculiar cases coming to the court. I'm making little diversion. There is a provision under our Juvenile Justice Act which provides for parents surrendering their child. As the Chief Justice of Karnataka High Court, a PIL was filed where grievance was made about acceptance of surrender of child under the Juvenile Justice Act. We had to summon the parents. Our effort to convince them was unsuccessful. But now, it's reality now. When the provision came under ZZ Act, empowering the parents to surrender, everybody thought that this occasion will not arise, but these occasions are arising. I came across one more shocking case where one of the offences alleged was under POCSO against male family member of the child. There was a petition filed under section 482 for quashing, in which the mother, who was the complainant, files an affidavit that there is a settlement of the dispute, and due to misconception, the complaint was filed. We have to dismiss the petition. If such efforts are made by parents to thwart the proceedings, to cut short the proceedings, by agreeing to some kind of a compromise, the entire object of the act will be set at naught. Such shocking cases are coming before the court because as I said, the world is changing very fast. Therefore, I conclude the topic by saying that there is a serious need to conduct a scientific audit of the implementation of the provisions of the Act. It is only after we do that we'll be able to ascertain where we have gone wrong during the last 10 years. Which are the loopholes which need to be plugged by the intervention of the legislature? We need to have strict implementation of the provisions in the Act regarding monitoring implementation of the Act. If the authorities which are entrusted with the work of monitoring are not performing their duty, the legislature will have to step in. The legislature will have to perhaps make a provision where some of the eligible NGOs should be given this responsibility. It is only if those who are really interested in doing this work are given the work of monitoring the implementation of the Act, then there can be some effective implementation of the Act. The legislature needs to step in on this aspect. The director said some time back that students can play a very important role. I firmly believe that law students can play a very important role in spreading awareness about the provisions of this 2012 Act. These young law students can go to the schools and educate the girls about the provisions of this Act. They will be able to do it more effectively as compared to elders. I believe that this book must be translated into Marathi in a very simplified form. Because if it is published in Marathi in a very simplified form, this book, if circulated to schools and colleges, this book will be extremely helpful in spreading awareness about the provisions of this Act. This is an area where the law schools and law colleges can play a very active role. Before I end, I must give one illustration for the benefit, two illustrations I want to give for the benefit of young law students. There was a function of the Legal Services Authority in Pune. One old lady got my telephone number, cell phone number. I received a call on my cell phone number while I was in Pune. Those were the days when linking of Aadhaar card with bank account was made compulsory. Lady was staying alone due to illness. One of her arms was amputated. She called me up. She said that I went to a center for enrolling myself for Aadhaar card, and I was told that because I don't have fingers where my arm has been amputated, I can't get Aadhaar card. She asked me a question, sir, what I am supposed to do? How I am going to operate my bank account? I told the secretary of the District Legal Service Authority. I do not remember the name of the college, but he got into touch with some law college. Some students were paralegal workers. They took up the matter with the authorities, and full team of the concerned department went to the house of that lady, and she was given Aadhaar card within a couple of days. It is only because of intervention of the students. One more example which I want to give. I'm sure that the students of Symbiosis Law School must have done wonderful work, but I don't know it personally. Therefore, I'm sharing one and last example. of young students of Maharashtra National Law School, Mumbai. I was fortunate to be associated with the law school right from the beginning. The High Court Legal Services Committee was entrusted the job of overseeing rehabilitation of two villages. Two villages in Palghar district were acquired for setting up nuclear power plant, and new villages were created in the same name and people were rehabilitated. I held 15 to 20 meetings with all stakeholders. Some of you are not able to make progress. So I requested one of our retired district judges who is associated with the National Law School to constitute a team of young students. We prepared a questionnaire. The team of students went by buses to these villages. They collected data in a very scientific manner. They analyzed the data, prepared PowerPoint program. I called a meeting of all stakeholders, which also included the Secretary of the Nuclear Energy Department from Delhi. There was Additional Solicitor General of India. Two students showed PowerPoint presentation. That PowerPoint presentation was so effective that the Secretary of the department told me, sir, now we have completely understood the problem. And he gave me assurance that funds will be released and the central government will coordinate with various departments of the state government to extend full relief. So our young law students are very powerful. They are very energetic. We must fully utilize their services. I again thank the organizers for giving me this opportunity. I end by repeating what my sister Justice Shalini has said in the last chapter of her book. What she has said is that we should all make dedicated efforts by becoming accountable and answerable to our children. That's the most important message she has conveyed. Message that we have to be accountable. As responsible members of the society, we have to be accountable and answerable to our children. More so when our children are being exposed to abuses. I hope that this book will help not only academicians, but the social workers, the persons who are active in the field. I must thank the publishers and Symbiosis Law School for taking the lead and publishing this book. I thank all the participants, and I again thank the organizers for giving this opportunity to me to have interaction with the students. Thank you.
Thank you, sir. Thank you for your keen judicial insights into the critical subject matter of this book on child sexual abuse. And thank you also for bringing out the analysis in the need of certain relevant aspects of the POSCO Act as well. Thank you very much. To further enhance this discussion, I would like to invite Dr. Shashikala Gurpur, ma'am, once again, to deliver a prelude to the book. Over to you, ma'am. Ma'am, could I request you to unmute yourself?
Respected Chief Guest Justice Abhayoka sir, our Honorable Chancellor at Presidential Chair, Dr. Bimzundar sir, our Honorable Vice Chancellor, former Chief Justice Mohit Shah sir, and our dear Justice Shalini Pansalkar madam. Hearty congratulations on achieving this great feat, Justice madam. It's really a kind of humble attempt on my part on three levels. One is to contextualize the book. Second is to introduce the theme of the book and key provisions or key parts of the book. I should use the word key parts. We law teachers have this occupational hazard of always referring to the black letter law as provisions, but what we have here is something different. So the title of the book, as all of you would see and you have seen already, is Decoding Child Sexual Abuse. Now, on the cover of the book, which is a very, very attractive cover, we've got the two eyes staring at us. Are these eyes staring at the black hole or in the blanks of lack of empathy or lack of concern or lack of interest? And is it what this book is going to advocate for? aside from unveiling it or decoding it. And secondly, the blurb of the book, the back cover of the book, in publisher's capturing of the essence, clearly says that it explains procedural law, substantive law, and the need for sensitization of all persons involved in the trial process. And it has usefulness for all the stakeholders. And it also captures the best practices across the world in all these laws. Now, aside from having its function in international law, in the treaties related to child rights. Now, if I'm contextualizing the book, I would go one step further in emphasizing why, as already Justice Abhay sir said, we need to encode this content into the genes of law learning and practice, whether law learning is in the institute or in the judicial academy or in the lawyers academy. Now we have a lawyers academy, or in the practice, which is at different levels, and in the research, which builds this knowledge for further reform. The need to encode has already been emphasized by Sir in three facets. One is the disuse of the law by those who feel that this may harm their otherwise existing balance. Those who have subverted this because of many reasons, as Sir gave the example of the mother who was wanting to withdraw the complaint, or it is about development lawyering, which is one of the unique courses taught in Symbiosis Law School, Pune, where students engage in developing awareness modules, or is it about effective learning, which is beyond the intellectualization of law learning in terms of opening the hearts? I think the book has encoding value for everybody. Coming to the issue of timeliness, in this very real territory of Maharashtra, a few weeks ago, Bombay High Court clearly reprimanded the delay in reporting by the police to CWC and Juvenile Court in the case of a child rape survivor. Now, soon after that, in response to that, Government of Maharashtra issued guidelines to register it within 24 hours. Now, this is the kind of loophole that is gaping at us, which Justice Shalini Madam has very effectively brought out in different parts of the book, which I will quickly bring before you in the next 12 minutes allotted to me. Now, I was also looking at interdisciplinarity of this issue. I was reading about pediatric head trauma cases rising from 5.8% to 21% during the recession period. And during the pandemic period, the pediatric head trauma remained with the 21%. It did not increase, but there was a pediatric trauma. It didn't decrease. We also have the issue of increasing rate of child exploitation. During COVID-19 period, it tripled. It was a worldwide phenomenon, from 34 children on average to 103 children 5 years and older being trafficked or extorted. So we see in this book the relevance and context evergreen, and a lot of work yet to be done being emphasized. The book begins with a terse but very strong, very evocative, and very befitting foreword by Honorable Justice Dhananjay Chandrachud. And here, Sir talks about the author. I would like to share with you that the author of this book, for me, is a personal soul sister in the cause of law and justice. Justice Chandrachud sir emphasizes that she is a person with social justice commitment. He says that she has taken up an issue which is relegated to the sidelines. And he also emphasized how there is a disproportionate focus of criminal justice system, because the criminal justice system is focusing on adults. And this focus has been decoded by Madam. She has also decoded how there is a gap in all-encompassing sense across legislations on defining the child. I mean, this is pointed out and captured in the foreword by Justice Chandrachud sir. But this is a kind of glaring gap. Different legislations, especially Evidence Act, defines child in different ways. So the uniformity, lack of uniformity in the very understanding and defining of the child is one thing that needs attention, as pointed out by Sir. Secondly, re-victimization, or what Madam tells in the book about secondary victimization, is an issue which Sir emphasizes, where he says that the child lacks a vocabulary as the child lacks the understanding of sex or understanding one's own anatomy. So the very experience of abuse and sexual abuse is not understood as sexual abuse by the child. The child takes it as fondling. So this is a reality which needs to be understood by those who are responding to it. And we have no choice but to respond. We have no choice to be silent on the face of such a helpless kind of manifestation of injustice and pain and exploitation. Justice Chandrachud also points out how social side of immediate families staunch silence. The word he uses is staunch silence. And he says that Madam has highlighted how law reform is not the only solution and how she has brought out the deafening silence. He talks about it in quoting the example of Virginia Woolf's writing about how she herself, Virginia Woolf reportedly suffered from a serious psychological illness, and she maintained that it owed to her child sexual abuse. And Justice Chandrachud, citing the reports of Virginia Woolf's subjection to sexual abuse, also cites that many look at it as fantasy, but it is not something to be undermined. So there is a deafening silence about this experience. India's surveys reveal, which Madam Shalini has quoted from various authentic sources at different timelines, that every 1 out of 5 would have undergone child sexual abuse. Now, it is also very clear from author's own preface about her hard work of last 31 years, her updation of the law from her PhD thesis, and inclusion of the latest reports from NGOs and particularly from mental health experts. She sets out on a mission to impact justice, a mission to give voice to the concerns of the vulnerable, and she clearly restates that it is to wipe tears of those who are abused and to prevent abuse of the rest. She begins with a thumb in chapter 1, which I consider as a very important chapter, where without compromising on her ethical and non-disclosure obligations as a former judge, she balances the Archimedean independent space as a researcher while clearly laying out the forensic aspects and the ethics of anonymity, and sipping the emotions and the pain as an onlooker on the dais as a judge she would have seen. So these case studies which she brings out in chapter 1 are very, very important. What the foreword of Justice Chandrachud says in terms of banished to the sidelines is really brought to the front in this first chapter in the form of illustrations, in the form of narrations. So it looks like a courageous stance for a lady judge to provide such a thorough discussion of the inadequacies of the existing legal framework. So the work is author's delight, I think publisher's delight as well, researcher's delight, to those two eyes which are viewing this whole phenomenon with innocence. It's the same wonder that comes out in judge's pride and humility of rest of us who are academic scholars. So congratulations, madam. Now coming to the demystification or decoding, she has done an extensive decoding of the POSCO Act, as it was already highlighted, Protection of Children from Sexual Offences Act, and emphasis on creating awareness about the menace among all stakeholders, which is the crux of the book. And the book suggests brings socio-legal perspectives. It highlights the difficulties faced by the victims, police, and the judges during the investigation and during the trial process. The reason is the subversive social process. The remedy is perceived and entrusted to the hands of the legal process. So the hybridization of the two and helplessness of the two powerlessness of the two, and the power of the two. All need to be explored with the mutual respect and with mutual awareness and with an expert eye for the detail and alertness, not to overstate, not to understate, not to disrespect, and to balance. I think a wonderful job has been done. So the book also unveils the need for sensitization, for detecting these crimes, to prevent these crimes. And the subject of child sexual abuse, if you see, in terms of the observation of criminal justice system with the predominant focus on adults. So it's virtually a kind of binary, challenging of the binary between two phenomena, child versus adult, where the whole system itself is predominantly guided by the adult realities and experiences, and adults sitting in judgment, and also earlier precedents in terms of criminal justice going more from the adult experience. The child anatomy, which is very unique, which doesn't permit, for example, interpretation of rape as a penetration in terms of the maturity of the body, to mention one, is something that needs very validated, unique approach. So Madam has very much highlighted these things with the help of numerous case laws, about, as she herself told, more than 200 cases. The plight of these victims and their families are discussed in the light of the real experience. It also examines other statutes related to books. So in terms of Juvenile Justice Act 2015 and Indian Penal Code 1860. So it also talks about best practices relating to procedural and substantive law. It gives a checklist for synthesizing judicial approaches. When a judge is sitting in judgment, the job is made easy for the past judgments. Varied dimensions of the subjects with the interpretative richness, and the very important concept of child getting enamored or getting virtually afraid of the environment of the court. Justice Oak already highlighted about child friendliness, which is highlighted in the legislation. Madam also touches upon this aspect in very much detail in the idea of secondary victimization, both during the trial and during the investigation. So some of those nuances may come in the form of questions during the discussion with the author. But for the time being, the highlights of the book are practical tips for various stakeholders who are directly dealing with the case, a checklist of cases and a checklist to be observed, pointers for the judges, pointers for practitioners, police officers, social activists, NGOs, judicial academies, academicians like us, researchers, and all the students of law. I wouldn't consider students of law are confined to the academic spaces. The students of law go beyond that. All of us, once in the field of law, are forever the students of law, I must say. So before I move, now I move to the structure of the book. If you look at the structure of the book, we look at it in terms of various chapters. There are 8 chapters in the book, if you look at the structure of the book. And in the very first chapter, as I already told you, the real experiences are brought out, which posit the seriousness of the issue and posit the need for looking at law critically in a very effective manner. And all forms of child sexual abuses are described comprehensively in the next chapter. The taboo of incest, which is something which is closely guarded in the subversive spaces of the family, which are least acknowledged in this very identity and acknowledgement of sexual abuse, its prevalence widely, and its serious implication. For me, page 25 is very important because it's adding Dr. Rajesh Parekh's, Dr. Sheshadri's, and Dr. Chenna Basavanna, who are from the Nimans Institute, and Dr. Parekh is from the Jaslock Hospital, the angle of mental health perspective, the trauma. And then Madam also highlights the research ethics in terms of how we have to be very careful while making the child go through that trauma and reveal. In a way, she is connecting it to the end of the book, where she is highlighting how other countries' best practices of taking the narrative of the child later, when the child is able to go through proper counseling and when the child is adult, can reopen. We had this whole experiment in Ireland when the children could reopen a lot of sexual abuse experiences as adults, which they went through as children. So this kind of interlocutory opportunity should be something that India should be exploring. So it's very interesting to see and very, you can say, revealing to read this part in chapter 2, where she highlights the various citations, including Justice Desai's citation, where Justice Desai talked about the judge's dilemma in terms of fair trial and in terms of absent child. You know, the very idea of fair trial being very much fact-oriented, and interpretation of the criminal law being focused on the principle of let 1,000 guilty escape but not one innocent be punished, and how it results in a kind of injustice. And this idea of trauma that a child goes through when the physical sexual abuse happens, how it gives rise to neurological changes, including the difficulty to speak. I encountered this personally when I was researching on sex workers and speaking to them who were trafficked as children. 45% of the sex workers were trafficked as children, and we had to bring psychiatric social workers in making them speak and take many occasions to speak to them. The author also reiterates Pinky Virani's extensive work, where Pinky Virani even refuses to work with Ms. Kiran Bedi with the Tihar jail inmates who were child sexual abuse victims, because she found it too intensive to deal with. And she talks about how that experience remains unsettling throughout life. And in a very apt manner, Madam brings it at different points, these kinds of non-legal works, which are pointing to this menace. In chapter 3, she elucidates the prevalence in international and national context, how the widespread menace has been reflected with the help of findings of surveys from various NGOs and figures of National Crime Statistics Bureau. Particularly page number 96 and 97 demystify certain ideas. I can't read all of that in 10 minutes, but let me tell you one important thing. 40% of these abuses happen by near family members, trusted people, and Madam has also highlighted how these are the people who assume different roles, like I'll tell you later. She talks about 2 million child prostitutes, where state has the innate duty to take special measures to bring them out, and they are also victims of child sexual abuse. 80% of these child prostitutes are in major metros. Therefore, the myth that it is only in the dark dungeons of poverty or ignorance is broken by Madam. She has decoded that. 5 lakh forced into child prostitution every year talks about the magnitude of the problem and the underlying social reasons behind this. Now, the Child Line, which is a kind of NGO which is operating from Mumbai, Madam gives a big credence to this organization among others. She talks about how its role is very important, and it suddenly has the number of documentation of such survivors or victims. And the author also cites a lot of studies talking about why Indian children are vulnerable. Indian children are vulnerable for 2 reasons. One, sex is a taboo issue, so it is not discussed. Child thinks, then in those cases, child thinks it's child's own offense. Secondly, because it happens within the family. Thirdly, because of the family honor being involved, not being brought to the books. So legislation has taken care, but in reality, the gap between the text and the context is huge. Text and the reality is huge. In page number 99, Madam provides a very good table, which shows 4-fold increase in the offences registered under POCSO between 2014 and 2016. That shows how we are a country which is in crisis, our society is in crisis. Page number 103 states the gender dimension, where it says that among the victims, 5% are male children. Now, another important fact that comes in this chapter, which we all need to pay attention, maybe the journalists who are sitting here, I would invite your attention to this, as well as those who are in responsible positions to state care homes, etc., that runaway children phenomenon usually comes from such abusive homes. So the ramification is not only to the child, but also to the wider society, because society has failed these children. Page number 103, 115 speak about the idea of who are the abusers. It's very interesting. Preachers, teachers, relatives, neighbors, trusted friends, co-villagers, servants. So all of these more or less come within the areas which we would least expect to be an enemy of the child or destroyer of the child. 70 to 80% happen either in the home of the child or in the home of the perpetrator. So page number 125 reveals another shocking reality, which reveals Madam's courage and objectivity, which is a survey done with the judges by Sakshi, although it is a dated survey a few years ago, which shows that 50% of the judges in the survey believed that child sexual offense, sexual abuse is an uncommon one. So we need to come out of these blinkers as academics, as social workers, as NGOs, and as professionals in law. Chapter 4 of the book is dedicated to the physical and psychological impact of child sexual abuse on the child. It is interspersed with the works of Miss Pinky Virani, her very noted book which came in the mid-90s, Bitter Chocolate. She herself was a victim or survivor of child sexual abuse. It also unveils this chapter, police view, psychiatric view, in an elaborate manner, page number 139. I'm sure many lawyers will get more educated by looking at the wonderful work that healthcare professionals have done. I must tell you that during COVID-19 also, we brought many of these, we were involved with the Pune police, and we got the record of many such abuses being reported because of the health workers, ASHA workers, working in tandem with the police. Therefore, mental health and healthcare are very much associated, and they cannot be separated from issues of violence, and child sexual abuse is one of those facets. If you go to the next chapter, the chapter comprehensively discusses the issue in the light of reported decisions. From page number 194 to 211, an extensive, that is where her legal scholarship is writ large, and up to 253 on child-friendly approach as well. In chapter 6, Madam gives a comparative angle, and here she highlights the legal provisions and trends and approaches in other countries, particularly the advanced countries of USA, UK, France, and Canada, and Australia. Here she speaks about how their approaches are holistic, advanced, home-based investigation, and then video recording by the child allowed, child witnesses allowed, child need not be brought to the direct confrontation with the accused, and then delayed evidence is allowed, closed circuit investigation. We have the closed circuit procedures and investigation, but still the process needs to be more child sensitive is what Madam is highlighting. Chapter 7 deals with each and every provision of the Act with relevant case law, the locus, who can file the case. We have seen that complaints have been filed by neighbors who have heard the shriek of the child. It has been filed by passerbys. It has been filed by friends. It has been filed by relatives, if not parents. Majority of the cases will be by parents. Page number 376 onwards, we have got a checklist, and this checklist is very, very unique contribution of the book, and it will save the effort and confusion of many police officers, investigators, NGOs from a subjective interpretation of the law, because it comes straight from an expert. Page number 507 onwards, the lament about the poor implementation is seen, and page number 520 is very important for us, which talks about greater cruelty in casual blindness, citing a Supreme Court decision. Therefore, the prayer is to give such sense and sensitivity to the people who are in the leadership of judiciary. So this humble prayer talks about in the epilogue again, in terms of socio-legal angles, and she has given solutions in the previous chapter. And after that, in the epilogue, she says, that is the humility of the author, where she says this is only the beginning. And she says that law reform with the reform in life. And to be effective, it needs to be going in tandem with the life, which means there has to be a sensitive and well thought strategy by lawyers and by the community and the society as a whole. The annexure in the Act gives the text of the POCSO Act 2012, POCSO Rules 2020, which is the update, which strengthens the book as a ready reckoner of the existing legal framework and the cases which are writ large and dispersed throughout the book. So I really liked this sentence that law and life derive strength from each other. So while concluding, I would like to say that social approval of the law is very important for the critical success of the law. It's very critical to the success of the law. So this book and this book's content and this book's theme, which needs to be addressed by the nation as a crisis, may be as important as the pandemic that we are addressing. So the book, in my opinion, adds value to the existing literature for everybody, and particularly for researchers and for our curriculum, as I already mentioned. And in a way, what could add to the book, in my opinion, in the light of COVID-19 is hybrid mode of abuse, where technology is used to seduce the child because there is no direct access to the child. We have come across these cases in Madhya Pradesh and other places. And this is the agenda which is unfinished in terms of technological and cyber abuse of children for future authors and scholars. The book will also serve in terms of socioeconomic and cultural vulnerabilities and multiple compounded vulnerabilities, which the author has already unveiled in the prelude, but which is limiting the prosecution, which our chief guest, honorable chief guest, also mentioned. Now, the book accounts for a very good theoretical underpinning. What I liked was the emphasis on the constitutional emphasis on compensatory approach. It stands vindicated, compensatory approach to the vulnerable, in this case, children. So reversal of burden of proof, which is the cornerstone in such approaches. Therefore, expectation for the judicial officers not to go by the pure technicality, as Justice Chandrachud pointed out in Posha cases, or not to go by too many overburdening of fair trial notions in an objective sense, but to be positively discriminate towards the vulnerable. This has come out very subtly but strongly in this book. The book is an attempt to highlight the importance of balance between rights of the victim and interest of the accused in the judicial process. Otherwise, judicial process in the wake of fair trial overemphasizes the rights of the accused because it is more geared towards the adult and a general sense, not to the particular realities of the vulnerable, because the legislation still has the colonial legacy. The nuggets of wisdom, interdisciplinary scholarship, wholesome, holistic 360-degree treatment, reflective observation, utmost compassion to those whose innocence is a burden, is the major gem that, or set of gems, you can find in this book. I wish all the best to the author with this beginning as an author and with this beginning as her compassionate venture and her expertise and scholarship. This message will reach loudly throughout the world. She would do a book tour, I hope, across the world, across this country first, which is a continent in itself with the 1/7 of the humanity, as the home of the 1/7 of the humanity. This book gets translated to all Indian languages, not only Marathi, because there are regions where child sexual abuse has been stronger in urban spaces elsewhere in India also, sir. And meta discourse, many meta discourse come in all forms, in media clippings, in other kinds of writings at the behest of the publisher. May this be cascaded, or may this have larger domino effect as legal literacy and socio-legal advocacy and initiative. All the best, madam, and congratulations once again. And I thank the august dais.
Thank you, ma'am. Thank you for that excellent address and for throwing light on the context, the relevance of the book, and highlighting the social as well as legal aspects of child rights, especially child sexual abuse. You brought out the essence of the book through your structured prelude, which certainly whet our appetite. So thank you. Thank you for that, ma'am. I would now like to invite Dr. Shalini Phansalkar Joshi ma'am to a conversation regarding the book, and I would like to request Dr. Shashikala Gorpur ma'am to conduct the conversation with the author.
Respected August Dias, especially with our Honorable Chief Guest Sir and our Honorable Chancellor Sir, our Vice Chancellor Madam, Justice Mohit Sir, and most of all the center of today's whole discourse, dear Dr. Justice Shalini Pansalkar Madam. Welcome to this conversation. As I invite you to the conversation, I look at you as a soul sister in terms of commitment to the cause of law and justice, commitment to the cause of the vulnerable. And you have always come across as a person who is youthful, open-minded, positive, always a yes. I mean, as a visiting judge scholar, you were not only there for teaching procedural laws, giving guest lectures, but also as evaluating the skills courses, evaluating student performances, delivering the prestigious public lecture, Justice late Chandrachud Memorial public lecture on gender justice, be it the question of evaluating the presentations of PhD. I think you are one of the rare judges who is multifaceted, and I welcome you to this conversation. And I don't think I can do any greater claim of unveiling your greater persona with that mesmerizing smile and humility. Madam, I would begin with this question about Virginia Woolf. Virginia Woolf's one of the celebrated works called A Room of One's Own. She laments how Shakespeare became a great poet, but his sister Janet remained in the labyrinths of darkness because Janet never had a space of her own, room of her own. So in such a gendered landscape of society, where women like you have become some of the front runners in creating and rewriting her story and history, my question to you is, could you tell us about your background in terms of being 31 years in the judicial post, and prior to that, maybe 20 years in legal field as such, and bringing out the woman power in that care and concern and motherliness in all-encompassing, very democratic approach to the issue, and remaining very clinically distanced from the phenomenon, managing the emotions with such a grueling role of looking at the reality of these innocent children. From Karat to such authorship, which is to be national news and international attention today, would you enumerate to us what made you take up the justice and law mission as a lady, where I'm sure in your times, 10 years ahead of me, before me, it wouldn't have been easy, because in my undergrad college, I had 8 girls in a class of 180. So could you please tell us about that?
Thank you, Dr. Shashikala. Before answering the question, I would say place my gratitude to Honorable Justice Oak, Justice Mohit Shah, so many judges who I mean, in my address, I could not see them and therefore could not mention them, but Justice Roshan Dalvi, Justice Gautam Patel, Justice Sarang Kotwal, Justice Midula Bhatkar, and so many others who I may not be able to see. But thank you all, and Justice Oak for a wonderful exposition, and Dr. Shashikala for, the book, the preview which you have said, I was also wonderful. I mean, I was so glad. So my background, if you ask me how I could get into the judiciary, because of my fathers, especially the inspiration. My one sister became doctor, and then other profession, which was known at that time, was legal profession. And therefore I joined, and it was the continuous encouragement and support from my family, both the families, which helped me to achieve various success. And so far as this writing a book is concerned, I still sincerely feel that I consider it my pious duty and obligation towards these children who were coming before me, especially when I was sitting as a special court for atrocities against women. Not a single day passed where there was not a case of child sexual abuse. The victim of sexual abuse may be a small child of few months, few years, or she may be an adolescent girl or a girl of a teenage girl. I mean, the abusers coming from different background, different ways, variations may be in the details of the incident, maybe in the abusers, but impact which the child was suffering during this process of giving evidence, during the process of investigation, everything was the same. So the details of story may be different, but the trauma faced by the child and the shock experienced by me and all the stakeholders in the system, because we were facing the same trauma. I mean, it was not only the trauma of the child, but the difficulties and the trauma faced by us, maybe as a judge, maybe as a public prosecutor, maybe as a defense counsel, was the same. And that really impelled me. I felt that I must do something. And what can I do? Then I got the exposure when I went for the training on gender and law to UK. I found various innovations made by them in their procedural law, in their substantive law. I mean, it was not confined merely to the rape or violation of modesty, but it was going beyond, just as now we find in the POSCO Act. But during the period when I was working as a judge on the special court for atrocities against women, there was no law. I had to innovate my own ways of how to record the evidence of the child. I mean, with sitting on the dais, that used to be just impossible. I cannot keep a hand of assurance to the child. I cannot, the child was not audible, but then I shifted that a recording of evidence to my chamber. At that time, I felt that, okay, I am able to do it, but what about others? I mean, I must, being a presiding officer of the judge, at times I was finding myself helpless to reduce the trauma faced by the child. Then how can I change it? So why not act as a change agent? Why not suggest the integrated response to this phenomenon where there was total ignorance and a denial as to the occurrence of such incidents, which I was facing from everyone. They used to say that it is a foreign phenomenon. You had been to England and therefore you are talking about these cases. But then my daily board were giving different reality. So I felt that awareness has to be created, sensitization has to be there. And that really impelled me to undertake this project. And I got my PhD for the same, that is okay. But thereafter, I could not publish the book, though I was advised by several. Now, after retirement, I got some more relaxed time. The judicial constraints of judicial office were also not there. So I could write. And I found that this subject has become far more relevant because of the number of cases being filed in the courts. I mean, there are more than lakhs of cases pending all over India, and Supreme Court has to take the initiative of giving direction for establishing more number of special courts and the sensitive handling of these cases. The day in and day out, we are coming across various decisions where it is necessary to highlight all these aspects. And therefore, now as the subject has become more relevant, I undertook this journey and exercise of writing the same, especially when COVID and pandemic and lockdown provided me the relaxed time.
Great, madam. Your presence has inspired us also. What our Honorable Chief Guest Justice Oak sir mentioned about Aadhaar card, that was by our own law school team.
Oh, great.
So I'm sure that you have been inspiration to many colleagues, many students, and I know that you have been our advisor to these strategies which are compassionate, effective learning for students. By effective, we mean learning through the heart, aside from the intellect, that straight connection to the brain. Now, coming to your own PhD, during the PhD, you had the opportunity, given your wide exposure in Warwick University's training. I remember I had visited during that time, and I was in the early stages of my career in Ireland. I missed the opportunity of talking to you, but another batch of judges I spoke to, you could have easily chosen something to do with domestic violence or family law. Why did you pick this subject, and how did your PhD impact on the law reform? Any takeaway on that for the audience, the students and other judges, please?
Yes, definitely. As I said, I was sitting in the special court for atrocities against women. There were more cases of sexual offenses, especially when the victim is adult, maybe in domestic violence. The things were not as difficult, as traumatic, as anguishing as that of when child is there in the witness box, and that too states about the sexual abuse. I mean, child has no vocabulary of its own. Sex is still and at that time, 20 years back, it was a completely taboo subject. Child doesn't know the names of its own anatomical part, private part, what to say about the private parts of the kids and how to describe that event. No special methods. Now when I went to England, I found that they are doing various innovative ways, like child will be explaining with the help of dolls by drawing the picture and so many other methods as to what has actually happened. But in India at that time, there were no such means. And my exposure in the gender and law course in England made me aware of the innovations which they have made, the various child-friendly procedures which they were adopting. And at that time, I felt that this is one area which is still unexplored. And I must say this now, this is a best platform to say, in our gender and law program, I had conducted the training program for the participants in England, and Justice Krupal, the Chief Justice at that time of Supreme Court, was there to attend that program. And he was very impressed with the suggestions made by me in the substantive law and procedural law, and he took that paper with him. And I am happy and really proud to say that in the Sakshi's judgment, Sakshi versus Union of India in 2004 99 judgment, he has referred to all these suggestions without, of course, naming me. And he has also called me and told me that, yes, I have taken whatever suggestions you have made to the logical conclusion. So this was an area for which I felt from my heart. And this was an area which was not at all explored. Everyone talks about domestic violence, maybe sexual violence of the grown-up ladies, but no one was at that time ready to talk or whisper about child sexual abuse. Though these cases were there in multiple, and as I said, except for the book of Pinky Virani, Bitter Chocolate, there was, and that of Mahrukh Kedinwala on child sex, there was no other book on the subject. And therefore, I felt that having the experience of judicial work, actually myself conducting the number of these cases, I mean, I was overflooded with the cases of 750 sexual cases, being the special court for atrocities against women at Pune. And therefore, I felt that I am at least, I felt myself that I am having the experience, so I may be the better person or better qualified to write this. And therefore, I took up this subject. Until today, I feel that we don't have many subjects on, I mean, many books on this subject. Hardly, still today, our reference book is Pinky Virani. And therefore, I felt that her was more on social self-experience. But for me, it was legal issue also, apart from being a social and psychological trauma. Legally, we have to make a lot of changes, I mean, both in substantive and procedural laws. And now those changes are all the more necessary, especially in the implementation of that. Ultimately, the success of the legislation lies in its implementation. And that
if I may bring you again back to this idea of the book Decoding the child sexual abuse. What are you decoding exactly? Why is it a different kind of decoding? I congratulate the publisher for providing this kind of an opportunity for you in updating your research and then bringing it in a time when there is a specific legislation addressing it. I remember when we were doing legal literacy sessions in the early part of my career in communities, we said women means and includes women from the womb stage, I mean embryo stage. So because the less talked about and especially protected about, more vulnerable child stage wasn't addressed by the law. So I agree with you, except as an object, like in case of child custody or things like that. So this is given that empowerment as a legislation, but you have seen through the transition. You have been the judge in the pre-legislation period. So you are an authentic voice from that point of view of the march of the law. And at the same time, you could see how this march is not very super fast. It's not well equipped. So OakBridge providing this kind of a forum for you and opportunity for you, providing its editorial support and publishing platform, I would say has done a wonderful job in terms of even the style of the book, not being lost in the textbook style of legalese or too much of jargon, but in a very reader-friendly way. So I would like you to tell the audience here, what exactly is being decoded? Is it just the myth? Is it the socio-legal dimension? Is it the law per se, or all the three? And if you could tell us which exactly are the strongest myths that you have attempted, and is it an exhaustive list that you have tackled, or are there few more waiting to be decoded?
Thank you. What I have tried to decode is entire concept of child sexual abuse, because it is shrouded in mystery and privacy. No one openly talks about it, no one discusses it, and therefore whether it is prevalent or not, and actually what constitutes child sexual abuse. I mean, it can be subtle, it can be brutal, it can be virtual, it can be physical, non-physical, even disrobing, kissing, or showing the child pornography. Everything is child sexual abuse. And there is not much awareness about the same. There was also not much awareness about who can be the offender. He is not a monster, villain, or someone of whom we can be afraid of. But he is a normal, ordinary person from your own family, from your own acquaintance, from your friends, from your teacher, sport teacher, even the religious preacher. Anyone can be, and we are not, I mean, we are allowing the child to be with the company of only those persons whom we know, but they ultimately are the major abuse part of constituting the major part of abusers. So all these myths that such offences cannot happen in Indian society, this is a Western incident, or whether what constitutes child sexual abuse. Earlier it used to be only the rape or violation of modesty, 2 offences only. But now we are understanding the various aspects of child sexual abuse. I also wanted to decode the impact of child sexual abuse. Especially, it is very damaging, devastating, shattering experience for the child, and it is equally difficult experience for the judge, prosecutor, and the defense counsel also to conduct these trials. I also wanted to shatter the myth that the laws are adequate. No, the laws are not at all adequate. I also wanted to say that the object of the law cannot be only to punish the accused.
Yes,
what the child wants is the healing process from the trauma, and for that purpose, everyone has to work. So the object was to explore this subject from all the angles, as many as possible, to make a comprehensive study of the same and to suggest some changes in our handling of the subject.
Madam, I would like to focus on that healing dimension which you mentioned, which may not be per se legal dimension, but then you brought a very rich interdisciplinary context and interdisciplinary data there from the experts in Jaslock Hospital and mostly in Nimans. I mean, Professor Sheshadri has been doing a wonderful job. So even you drew on Pinky's work and then Flavia's work, Sheila Barse's work. It's commendable that you have kept this interdisciplinarity, attended those seminars and collected those literature and NGO work. Now, as a mentor of future judges, how do you think this kind of interdisciplinary knowledge is important for law students, law graduates, and lawyers and future judges, and how judicial academies can incorporate these points in changing the narrative or in influencing the narrative by the judges? Again, in the binary conflict of fair trial versus the compensatory approach, positive discrimination to be taken, particularly in interpreting the idea of physical contact. So 2 parts of the question. One is how, second is physical contact interpretation.
Okay, so far as the Act is concerned, the Act has made it very clear what will amount to sexual assault, whether it is physical contact, in which terms, I mean, in which context that term is used, and how the Supreme Court judgment is elaborating the same Supreme Court judgment as to how this word is to be used to advance the cause of the legislation and not to be pedantic or in any way technological. So it is a very wide term in that sense. As regards, multidisciplinary approach, I must say that this is a socio-legal legislation. So it is, the subject does not pertain to law at all. It pertains more to our handling of dealing with the children and their issues. So it is more for the society's issues, how to respect the bodily integrity of the children, how to believe in children, how to take their case forward and create that circle of confidence with the children. So once we know the impact, once we know that such cases do happen, once we know that the abuser in such cases is someone known to the child, then only we will start implementing the law in its proper perspective. And therefore, for such subject, which is socio-legal, maybe domestic violence, maybe sexual offences, especially child sexual abuse, the judge, the law student, the advocate, defense counsel, AP, everyone must have the knowledge of these issues, what impact his cross-examination, his examination in chief may have on the child, how the child has come up to this stage of lodging or giving the evidence. So these issues, if they know better, then their handling will be also sensitized. They will also feel concerned about the trauma of the child, and they will not ask the questions, or they will not insist on technicalities. The judge will also be in a better position to give the decision. And that is why I feel that the subject cannot be called as a uniform bracket or jacket or its answer, but it has to be dealt with from all the possible angles, especially psychological angle, which the psychologists and the field have said. There is a concept of grooming, which is highlighted by Dr. Shekhar Sheshadri. We are not, we may not be aware that the abuser takes the child in confidence, says that it is a secret between you and me. If you disclose the secret, then I will not pamper you. I will not give you the chocolate. I will not give you the gifts. So this process of grooming, sometimes child doesn't understand. And then we feel why there is so much of delay in lodging the complaint, why the child has not lodged the complaint when it was necessary, why the child has not disclosed about the incident. The disclosure, delayed disclosure, behind delayed disclosure or lodging of complaint, there are several factors, psychological factors, the impact, the child losing everything, interest in the life. So many things are there, which as a judge or as a legal stakeholder, we must understand. Then only we can, do the proper justice to that child.
Agreed, madam. So the next question to you, just two more questions. One question is, where exactly can the community role be better? Like in most of the cases, you have said that not just forensic experts' opinion to be the sole ground of conviction or acquittal, but also to be examined in the light of precedents. You have drawn that, which I have highlighted in the highlights of the book. Now, where exactly is community's role coming in as a neighbor or as a relative or as a teacher or as a doctor, for example? So could you please quickly say about it in terms of your decoding doctrine? Yeah.
Yes, what I feel necessary is awareness about not only the parents, school teacher, but also of the society as such, which includes the neighbors, which includes the principal, which includes the several other persons also. In one of the cases before me, the girl was of, and which I have quoted in my prelude also, the girl was of 8 to 9 years of age. Her stepfather was making sexual advances towards her, watching her when she was taking bath, when she was disturbing herself. She disclosed about it to her mother, but mother was of no help because mother was already in the awe of her husband. She was not saying anything. She just told her daughter to keep quiet and not to say anything about it, not to disclose about it. Ultimately, one day it happened that the daughter was alone in the house. The father committed rape on her, left for the job, and then the daughter, she draped herself with kerosene, put herself in the flames. The mother was totally devastated. But at the time of trial, what happened, she became hostile. Maybe because she was having two minor siblings, children, for whom she has to look after. Her husband was there. Then what was the evidence before me? At that time, the neighboring aunt to whom the child has disclosed about it, she came forward, she deposed that this was the case. Then there was the dying declaration at the last moment recorded, which was not so coherent, but with the help of this corroborative piece of evidence, I could tell me, maybe because, the mother she was helpless herself, she was powerless, she was dependent, but the guilt which she has ultimately felt always remain with her. But I could do it merely because there was some neighbor who was coming forward to state about the same. So the role of parents, society who are to disclose about the same is very, very vital. And as regards the children, also creating awareness about in them, about good touch, bad touch, letting them know is important. Just 2 days back, there was a case reported from Kerala Special Court of POSCO cases, wherein the child was made aware of these bad cases, bad touch and good touch, and on that basis, the accused could be convicted. So the role of awareness and sensitization of the community, of all the stakeholders who deal with the children is of vital importance. Especially law students. Law students are going to be one day the either defense counsel, public prosecutor, or even the judicial officers. If they inculcate this awareness and sensitization at this stage itself, it will go a long way in sensitizing the entire system as such.
Madam, you have a lot of your colleague judges here. Justice Mridula Bhatkar Madam has written in the chat line that you have always been a role model for the judges, especially in academics. And she congratulates you. We have also seen, ma'am, that some of your judgments have been full of innovation, and I think the same innovation got reflected in the book. We have many of your esteemed colleagues whom I look up to as resource persons, like Justice Roshan Dalvi is an authority on child law, and then Justice Vibha Kankanwadi, Justice Kotwal sir, Justice Patel. So we have large number of your esteemed colleagues in addition to this August dice, which is visible to me within the limited space of my laptop. So ma'am, my last question to you is, now that you have established your impression as an author, we have studied your book and we are very impressed, and we are very, we can connect to it, and we see a lot of impact of this research and work. So are you planning a sequel in next 2 years, or what is your next focus? Will it be another vulnerable group? Because I always would, as a teacher, I would like to see that good students do better.
God willing.
Of 20 accounting for 80. Yes.
God willing, maybe. I will not say anything at this stage, but yes, maybe.
Thank you very much, ma'am, for patient and very interesting answers to the question, laced with your experience, enthusiasm. I hope that becomes contagious in all of us to share her mission and to stand by that mission of doing good to the vulnerable and to children in particular. Thank you, Ananda. Over to the company.
Thank you, ma'am. Thank you for that invigorating conversation, just diving and giving us deeper insight into the issue of child sexual abuse and its interaction with justice. We have received several questions from the participants and students, and due to the paucity of time, we will not be able to go through all, but I was hoping to get your response, ma'am, Shalini ma'am, on a couple of these questions. So one of the questions was, our cultural and social reasons make parents feel that girls are more prone to such crimes, child sexual abuse, and neglect the male child in the process. Also, when the parents take a stance of disbelief about the sexual abuse, about the event, then the children are discouraged from disclosing, like you just mentioned, disclosing their bad experiences, especially for boys. So what would be your opinion? How can we make any changes to start dialogue, parents to dialogue with their kids in order to make them more comfortable talking about their experiences?
For the parents, I would sincerely request that start believing in your child. Start having a good dialogue. I mean, establish that dialogue between you and the child. And for that purpose, respect his own privacy, dignity, and also the bodily integrity. The child must feel safe in disclosing anything to you. If you start ignoring or saying the child to keep quiet, the child will not disclose further things to you. So it is very important to have that, communication with the child, and that can be definitely established with your good intention, with the quality time which you are able to spend with the child.
Thank you, ma'am. Thank you for that. Gurpur ma'am, could you unmute? I see you
Yeah,
speaking.
sorry to join you in this in which I am not scheduled, but I would like to bring to the attention of Madam and to the august audience, what kind, this is the question which is coming from a practitioner, which is Dr. Priyadarshini Kuraje, member Juvenile Justice Board, Kolhapur, who asked the question, what kind of infrastructure need for rehabilitation of both victim and accused if he is juvenile?
I mean, accused is juvenile.
Yes, that's what ma'am is asking.
Okay. So far as juvenile, we will call him a child in conflict with law instead of calling as accused or juvenile. Juvenile Justice Act provides several measures or disposition orders under Section 18 of the said Act, on the basis of which the rehabilitation of such child in conflict with law can be achieved. There are several ways laid down. I mean, one may be community service, one may be under the Probation of Offenders Act, one may be giving the child in the custody of, under the supervision of the parents. There may be certain, ways of providing counseling to him, maybe group counseling, individual counseling, knowing the requirements of the child and understanding those requirements, providing various ways of rehabilitation and reintegration into the society. That is so far as regards child in conflict with law who has committed the child sexual abuse or committed the offense. And that may be possibility because now the consensual age for the consensual sex is increased from 16 to 18 years under the Act. So under the Act, any person who is below the age of 18 years can be a victim. Naturally, in case of romantic relationships, where both of them may be in love with each other and having experimented the sexual incident, relation, and then one becomes a child in conflict with law, being a boy, and one becomes a girl who is a victim. So in such cases, these various ways of rehabilitation are required to be found out, because here the question of consent becomes irrelevant. So these are very gray areas and very crucial cases under this Act, and the challenge is thrown open before the judicial officers, which they are required to deal with it, because the relations may be romantic relationship, as we call them sometimes, and where the consent we also cannot call to be as a completely free consent, knowing the consequences, impact of that. So there are various issues for especially child in conflict with law. We will have to turn to Juvenile Justice Act, which provides the ways for their rehabilitation.
Professor Lasya, any more questions?
There are several, ma'am. I just thought we'll just take. Yes, ma'am.
You'll be sticking to how many?
Just one or two more.
Yeah, because what is repeated in interview and then review.
Yes, I'm avoiding this.
Yeah.
Yes. Yes, ma'am. So another question, as Dr. Gurpur ma'am had noted in her prelude, was regarding the post-pandemic challenges, because post-pandemic we are seeing that online offences against children have surged. So how can law have an intervention according to you in order to take action against such abuses?
Post-pandemic, there is increase in not only in the cases of domestic violence, but also of child sexual abuse. Ultimately, child sexual abuse takes place in the privacy of the home and on the basis of the opportunity which the abuser may have with the child, to be with the child. Naturally, during this lockdown, during this pandemic, everyone is working from home or being at home. And therefore, there are increases in the incidence of domestic violence and child sexual abuse. Childline is operating 24 hours whenever any such complaint is received, or even the child picks up the phone and does not speak also, the childline, they trace the call and ensure that the child gets the requisite help. There are also the helplines given by the Women and Child Development Department, which are given wide publicity even on our TVs and even social medias, where the child can approach whenever there is apprehension and whenever there is commission of the offense. And as I said, unless and until the parents and the society, the neighbors, everyone who is a stakeholder in the society, is aware and takes prompt action, such offences cannot be stopped. So they have to be more careful, they have to be more vigilant, they have to be more understanding, they have to be more believing to the child.
Yes, thank you, ma'am. And just one more question finally, since you have an experience in the legal field as well as you've been so involved with education. So the question was at an intersection of those two. So is there a need to revise our law school curriculums for better child rights sensitivity? And secondly, where do we stand in terms of sex education in schools?
Very good question, because we have to start giving emphasis on sex education and on the aspect of sexuality. What will be the consequences of indulging? Because nowadays there is, early exposure to all the things because of the social media, TV, etc. Children are getting mature at the early stage, and that we are recognizing in Juvenile Justice Act. We are creating, a special category of children between 16 to 18 and dealing with them separately. But so far as child sexual abuse cases are concerned, we are having the, not that much awareness, and for that purpose, we have to really work on this, and that can be done through the legal education, sex education. In the curriculum also, the law school curriculum, we are having IPC, CPC, CRPC, Evidence Act, substantive laws, but we must highlight on the socio-legal legislations like Domestic Violence Act, Juvenile Justice Act, POSCO Act, PCPNDT Act. All these laws are closely connected with our life, with our society, and therefore sensitization about these laws, understanding on these laws is also required to be included in our curriculum. So gender justice education, gender equality session, they should be started, inculcated from the school itself, respecting a girl, respecting a lady. All these things ultimately go to from your own home education to the school education to the college education. So respect for the child rights, respect for the women's rights is of paramount importance, and that has to be inculcated. Like charity, it should begin from home and should be continued throughout the life.
Well, thank you very much, ma'am, for answering all the questions. There are several more, but because of the paucity of time, we will end the question and answer session over here. It is now my honor to call upon our collaborator for this event, the director of OakBridge Publishing Private Limited, Mr. Shrish Chandra, to deliver the vote of thanks. Mr. Shrish has 25 years of rich experience cutting across publishing and education industry. He was a sales executive at Tata McGraw-Hill Publishing Company, and then he went on to work with some of the most prestigious names in publishing, such as Time, Macmillan India, Walters Kluwer, LexisNexis, and he was also the senior director and head of online solutions and content creation and acquisition at Relix Group. Currently, he is the director of OakBridge Publishing Private Limited. I would like to invite you, sir, to kindly deliver the vote of thanks.
Thank you, Lasya. I must admit, before I go forward, I must admit what a great session it has been, and I have loved every bit of it. It was a delight to be a part of this session. Good afternoon to all the dignitaries and the audience who have joined us today for the visual release of the book Decoding Child Sexual Abuse, authored by Dr. Justice Shalini Bhansalkar Joshi. On behalf of OakBridge Publishing, I thank Symbiosis Law School and especially Dr. Shashikala Gurpur, Dr. Vidya Yaravdekar, and Dr. S.B. Majumdar for organizing the book release and the discussion on this crucial subject. We are also grateful to Honorable Justice ASO for gracing this event and releasing the book. Thank you, Professor Lasya Vyakaranam, for moderating the Q&A session, and that too so well. We are the proud publishers of this valuable book, and we profusely thank Dr. Justice Shalini Joshi for entrusting her maiden book to us for publication. Before I go ahead any further, I would like to extend a special thanks to Dr. Gurpur for decoding the book so well and in absolute detail. Ma'am, I must admit that you are a publisher's delight. Now coming back to the book, as publishers, what appealed to us was the approach of analyzing the issue of child sexual abuse in India from a socio-legal perspective. Sexual abuse against children is a major area of concern for enforcement agencies in India, especially given the growing instances of online child sexual abuse. The number of cases reported are much lower than the incidence rates as in case of child sexual abuse. The perpetrators in most cases is an acquaintance or a family member, and there is a social stigma associated with the sexual abuse. Dr. Joshi has drawn from her own experience and learning as a judge and an academician while examining the Protection of Children from Sexual Offences Act 2012 and other relevant statutes in the book. The author highlights that change in the approach and mindset of the society is extremely important for any law to succeed in addressing the deep-rooted issue of child sexual abuse. Emphasizing on the need for a holistic policy towards preventing and deterring child sexual abuse, the author evaluates the legal framework in other jurisdictions as a reference point in formulating best practices in India. I hope the readers will find the book valuable and it will help further the discourse of the subject and forward for policymakers. Thank you so much. It was a pleasure being here at this event.
Thank you very much, sir. Thank you for that wonderful vote of thanks. And before we go on to the national anthem, I would like to request all the honorable judges, Roshan Dalvi, Vibha Kankanwadi, Mridula Bhatkar, Justice Gautam Patel, Justice Sarang Kotwal, as well as the directors of our sister law schools, Dr. C.J. Ravantle, Dr. Anuradha Binuri, and Dr. Sukhwinder Singh Dari, along with all the dignitaries, to please turn on your cameras for a group photograph.
And Justice Mohit Shah, sir, as well. He's
Yes.
on the dais, but once again, acknowledging his august presence. I think, Roshan ma'am, you may have to be in the center of the, that's nice.
Thank you so much. Yeah.
Great.
Congratulations, Dr. Shalini.
Yes, thank you so much.
Excellent
I'm
work.
so happy that all of you have graced the occasion.
Yes.
Thank you, Roshan.
Good afternoon, Judge. Justice Oak. Very good speech.
Yeah.
Really enlightening.
Yes.
Yes.
Good afternoon.
Spending so much time on a Saturday.
Sir. Good morning. Good afternoon.
Good afternoon.
I request the IT team to kindly take a group photo, please.
Without delay.
Yeah.
Please.
Thank you to everyone.
Thank you.
Thank you.
Thank you.
We will now have the national anthem to conclude the program. So I request all the dignitaries and participants to kindly stand up for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उत्कल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
Thank you. I would like to take this opportunity to thank all the dignitaries who have graced this occasion on and off the virtual dais and all the participants. We once again congratulate Justice Dr. Shalini Fansalkar Joshi ma'am, on the release of your book. I would like to inform the participants once again that the book is available for online purchase by following the link that was on the slide. It has also been posted in the chat for a direct access. So with this, we have come to the end of the event for the virtual book release. The participants may now feel free to delink from the meeting. Thank you, one and all.
Thank you. Thank you.
Thank you, Judge Sir.
Thank you.
Justice
Thank
and
Thank you.
all judge friends and Shalini ma'am.